Hi, everyone. My name is Jason Hanford. I'm an attorney at Chartwell Law, and we're filming a video today that we would hope you'll watch about Pennsylvania workers' compensation, offset issues in Pennsylvania workers' compensation. And we're just going to answer some questions that our clients come to us a lot with on what is a pretty specific and limited issue, but it can be a pretty big issue depending on the case. So first off, I want to make sure everybody's doing okay. I hope everybody's all right out there. It's been a year. It's been an interesting year, a tough year. We hope that all of our friends at the firm, all of our clients, everybody's doing all right health-wise and life-wise and job-wise. We started doing these videos, I think, back in April, and we figured it'd be a month or two and we'd be back to life, as it were. And here we are again. So we hope everybody's doing okay out there. We're glad to have you as clients and as friends, and we hope to continue all of our relationships. As we always do on these videos, I need to clarify up front that we're not providing any specific legal advice today. So don't go out and make any bad decisions based on anything that we said. We're just giving you an overview of the law, as it were. If you have any specific questions about any of your cases, any of your claims, please do reach out to us. And to do that, you can either contact myself directly or Kaitlin Perry or Lee Fiederer, who are participating in the video today. You can contact all of us. Our emails and our phone numbers will probably be on this video somewhere. Or you can go to the Chartwell website, chartwelllaw.com, and we have a lot of resources there that you can look at that'll give you information and follow-up contact. So all of that housekeeping out of the way, I want to allow Kaitlin Perry from our Scranton office to say hello. Kaitlin, you want to say hi, everybody?
Hi, everybody. Yes, my name is Kaitlin Perry, and I am an attorney at the Scranton branch of Chartwell.
And then we also have returning for his, I don't know, fourth or fifth famous video in this series, Lee Fiederer from the Philadelphia office. Lee, could you say hi to everybody?
Jason, it's just the third video, but hello.
It only feels like the fifth or the sixth because I watch your videos so much, because
wow,
I can't get all the information in one sitting. Let's start with you, Lee. We want to talk today. A lot of these videos have been focused on COVID-19 and how it affects comp cases, because COVID-19 is kind of a big deal, for better or worse, and it's really impacting everyone in all of our industries, and it has affected Pennsylvania workers' comp. Specifically today, we're going to talk about the CARES Act. Can you start with what is the CARES Act?
Sure, Jason. So the CARES Act was a federal act that went into effect in March of 2020, towards the end of March 2020. The specific issue I want to address today is the unemployment compensation provision within the Federal CARES Act. The Federal CARES Act was part of a much broader pandemic relief effort, but there was a specific provision dealing with pandemic unemployment compensation benefits paid by the federal, not the state government. And that's what I want to focus on today.
Let me start you out from the applicant's perspective, Lee. When you say it's a federal benefit and it seems to run with workers' comp, with unemployment, do you apply for the CARES Act benefits when you apply for state unemployment? What's the practical approach that an applicant has?
So when the applicant was eligible and was receiving state unemployment compensation benefits, there was a $600 supplement that was available to them upon request and application, paid by the federal government. And that benefit ended up running from March 27, 2020 through approximately July 31st, 2020. Those are approximate dates. But from what I gather, anyone who was receiving state unemployment compensation benefits, not just in Pennsylvania, but actually nationwide, was eligible to receive a $600 a week supplemental federal benefit. When you add it up, it was $10,800, and it ran concurrent with their state unemployment compensation benefits. Jason, one other thing about the federal supplement, there was actually an additional benefit. It was not a supplement, but it extended state unemployment compensation benefits for an additional 13 weeks. So whereas people would traditionally have gotten 26 weeks of state unemployment compensation benefits, they were eligible to receive another 13 weeks for a total of 39 weeks of the state benefit, which is exclusive of the $600 federal supplement.
And Lee, I'm sure you can confirm, and as some of our clients probably know, $600 per week in the unemployment compensation setting is not an insignificant amount. That's a pretty large number.
Right. I mean, look, first of all, just to draw on a national level, I want to talk about like one state, Michigan, for example, because there's some case law out of Michigan dealing with federal CARES Act unemployment compensation benefits. In Michigan, the most you can receive on unemployment compensation is $392 a week. So the federal supplement was pretty significant. I think we've seen some stuff out of Florida where the amount of unemployment compensation benefits, Jason, you and I talked about this once. I think that in Florida, the maximum unemployment compensation benefit may be less than $300 a week. So in any event, someone who was receiving only, let's say someone who was receiving only $180 in state work unemployment compensation benefits and was only making, $500 a week, could have conceivably received more in federal and state unemployment compensation benefits than they ever would have dreamed of making if they had stayed at work. So it's not insignificant.
Yeah, just to clarify for our viewers, and I should have mentioned at the outset, if you have any questions for us and you're on the social media websites that we post on, or you're on YouTube, you're welcome to chime in the comments with any nice comments, any feedback you might have, maybe not the mean stuff. But the reason I bring that up is we're not here today to debate the policy aspects of the CARES Act. It's interesting from many perspectives, but I think really why that becomes an issue is it magnifies, in my mind, the importance of the interplay between workers' comp benefits and UC benefits when the UC or the UC benefits plus CARES Act becomes a much larger number. It becomes a bigger issue, I would think, in the litigation. So in that mindset, Lee, what happens in Pennsylvania if we have somebody who's perhaps litigating a claim petition and they end up having the claim petition granted, but they also received, we assume this is a situation, UC and CARES Act benefits in the meantime.
Right. So this is why we're talking today. This actually popped up on one of my cases where a claimant agreed that we were entitled to an offset for his receipt of state unemployment compensation benefits, but disagreed whether we were entitled to an offset based upon his receipt of the $600 federal unemployment compensation pandemic relief act CARES supplement. That's a mouthful. So we're litigating that issue.
Before you get into your learned response, which I'm sure is the right one, what was the claimant's reasoning? Are they arguing that it was paid by the federal government, therefore it's none of the state actors' business? Or what is their argument to exclude the federal benefit?
So their initial argument, and we have not briefed this issue yet for the judge, so I'm anticipating additional arguments, but their initial argument was that this is real. Their checks they received did not say unemployment compensation on them. The check said they were a federal CARES Act pandemic relief benefit. So they were arguing that it wasn't an unemployment compensation benefit at all. That was their first argument. As we will see, however, in other jurisdictions, people have made exactly the argument that you anticipated, Jason, that it was funded by the federal government and therefore it should not have been entitled subject to an offset. So that's one argument people are making. And just to be clear here, I'm no sage. I don't know what the Pennsylvania courts will do with this on an appellate level. There's no case law on it. What I am able to draw on as we talk is some stuff that has come out of Michigan, for example, at what I would call the appeal board level, which does provide some pretty good guidance as to where states might head in general. Because although every state workers' compensation statute is potentially different, there is a lot of overlap and consistency. And for example, in Michigan, they have the same entitlement to an offset for unemployment compensation that exists in Pennsylvania.
We set aside for the time being the argument that it doesn't say unemployment compensation on the federal CARES Act check, which I think is interesting because I think some of the state UC payments are made electronically anyways. But if we set aside that argument for the time being and focus more on what we anticipate is going to come later in your case or in other Pennsylvania cases, that this was a pandemic, this was a national emergency, this was the federal government stepping in, not only to replace wages, but to stimulate the economy. What's your response to that, I think, somewhat logical argument going to be?
Right. So I think that what you've done here, Jason, is you've refined the question. The question really is more nuanced. The question should be, are Pennsylvania employers entitled to an offset when an unemployment compensation benefit is authorized beyond Pennsylvania state law? In other words, can a federal statute that's created, which pays in what really is an unemployment compensation benefit, does it affect the state law, which allows employers to take an offset based upon claimants' receipt of same? It's really a good question. Pennsylvania state employers participate actively in Pennsylvania unemployment compensation. and they help fund it to a certain extent, but they really have no funding involvement with the Federal CARES Act benefit. And in fact, a 1999 Pennsylvania case kind of addressed this in a different context. And in this case, the employer was denied its entitlement to an offset based upon claimant's receipt of a federal benefit. That case was called Dietrich versus WCAB. And the claimant was receiving a benefit under something called the Trade Readjustment Allowance Act. Basically, the federal government had created a benefit payable to employees who suffered because of foreign trade imbalances. And part of that benefit, in addition to job retraining and relocation costs, was actually a supplemental unemployment compensation benefit paid to employees. And in the Dietrich case, the court held that because even though the Trade Readjustment Act was administered by the state of Pennsylvania, it was funded by the federal government, and therefore there was no offset entitled. It's an outlier of a case, but it is probably the case most closely on point to what we have here, with the exception of a footnote in another case.
Well, that's my question. Without giving away your secret arguments, how are you going to distinguish the CARES Act benefits from the trade adjustment benefits you spoke about in the 1999 case?
Right. So it's going to be a little bit of a challenge. However, there's a 2008 case called Costa. And in the Costa case, in a footnote, it said that the employer had no obligation to prove what portion of unemployment compensation benefits was funded by the employer or the federal government or the state government, that the right under Section 204A of the Pennsylvania Workers' Compensation Act to take an offset was absolute, that there was nothing which could infringe on it. And as long as the benefit is cast as an unemployment compensation benefit, that the employer should be entitled to take an offset regardless of the funding source. So it's not as straightforward as you would think. When I first addressed this issue, Jason, it seemed obvious to me that it's a Pandemic CARES Relief Unemployment Compensation Act. No matter how claimant wants to title it, there actually is a subsection of the CARES Act that refers to pandemic unemployment compensation. So it seems to me obvious that we should be able to get this offset. Let me just address, and then I think I'm kind of exhausted on the CARES Act stuff, but let me address how some Michigan appellate level, like appeal board level type jurisdictions have dealt with it.
Sure.
In two cases in Michigan, Jason, the appeal board level held unequivocally that the employer was entitled to the offset based on claimant's receipt of federal CARES Act benefits. They gave two reasons. They said ultimately the funding source for unemployment compensation is the government anyway. It's not the employer. And based on the overall fact that claimants are receiving the money from the government anyway, it doesn't matter which governmental source they're getting it from. So that's one argument that I think employers in Pennsylvania will have to make.
Okay. Do you have practical advice for employers in addressing this issue? I guess, other than, questioning claimants when they testify about receipt of other benefits, is there any sort of database or place you can go to see if somebody's a federal Claims Act, CARES Act recipient of benefits?
It's a really great question. In my case, that brought this whole issue to the forefront, I suggested to claimants counsel that claimant surely should be able to access a database on his own providing me a printout of what he received. He was never able to do that. I don't know why. I don't know if that database doesn't exist. It's certainly not available to us as the defendants or the employers. It's not something that's going to be within our purview. But just like a claimant in Pennsylvania UC can provide, log in and provide us a printout of what he's received in UC, this particular claimant denied the ability to do so. Here was my strategy in response to that. I kind of asked the judge to shift the burden. I said to the judge, look, it's not something the employer can provide. It seems to be something that should be within claimant's purview. If he doesn't produce it, I'm going to ask for an adverse inference that he received the full $600 a week for the full 18 weeks that the benefit was available to him. And we'll see what the judge does with that. But that's the strategy I'm employing.
Yeah, and I think, Lee, I'm sure you remember, and some of our clients might remember, that there was a time when in a parallel benefit situation, but it's also a federally run benefit, we could subpoena for Social Security records to see if somebody's receiving Social Security, retirement, disability, that sort of thing. We can't even do that anymore. So it might be something where the information is hard to get from the defense perspective, regardless of the measures that you take.
I would agree, Jason. Can I just close on one issue here when it comes to the CARES Act and UC?
Sure.
The second argument that was advanced at the Michigan courts was that really there is a policy consideration, and I'm not advocating for policy considerations. I'm going to just put this out there because defendants are going to have to make this argument, that claimants should not become more economically incentivized to remain off work because they'll receive more benefits off work than if they return to work. So that's certainly an argument that I think defendants will advance in this context. I mean, one thing that seems clear is that there were people who were able to do better, make more between state and federal unemployment than they ever would have made at work. And the Michigan courts did not countenance that idea.
Sure. And I think everybody's probably aware that while that particular CARES Act benefit has expired, there's additional funding being debated federally through legislation. So this might be something that comes back around that we have to be aware of going forward. So I think that's a good coverage of the CARES Act and those offsets. But what we wanted to do for our clients is give a more broader overview of how offsets work in Pennsylvania workers' compensation, which is what Kaitlin is here for. Kaitlin, Lee mentioned Section 204A, which sounds really fancy. I assume that's from the Pennsylvania Workers' Compensation Act. Can you tell everybody in plain language what that means, what Section 204A is?
Absolutely. So just for completeness purposes, we did want to go over the other offsets that exist under 204A, which was actually added to the act in 1996. And the legislative intent behind that was really to prevent double recovery. So there's 4 situations: unemployment compensation, which Lee went over in the context of the CARES Act. And then there is severance, pension, and Social Security retirement. So those are the 4 circumstances under which the employer is entitled to an offset under the act. For your convenience, that's in the Bureau regulations under Chapter 123, and they outline exactly how the offsets are calculated. And it's dollar for dollar, and it's based on the net amount received.
Which do we see in your practice, Kaitlin? Which do you see most frequently out of those 4? Is it usually unemployment compensation?
Unemployment compensation for sure. Yes, absolutely.
And we touched on it with Lee. Do you have practical advice on how to approach that? Is it? I assume it's usually in litigation of a claim petition. Do you always ask claimants about UC? Do you request records? What do you do in your practice?
Yeah, there is a case that talks about that. And I think for a practical purpose, absolutely always cross-examine the claimant about their receipt of benefits and the amount. Gross, net, make sure that's on the record, because there was a case that talked about that. I believe it was Costa, the case Lee mentioned earlier. And in that case, the claimant tried to say that the testimony about his receipt of unemployment and the amount wasn't enough for the offset to be applied. The court said, yeah, it was. Just because the evidence came from the claimant and didn't necessarily benefit him does not mean that the judge should not apply that automatically in his holding. So I think that, or in his decision, excuse me. So I think that absolutely ask the claimants and get that on the record. For completeness purposes, I think absolutely ask for a record of that. As Lee said, claimants can enter a password into their account and print that out pretty easily. So I would definitely try to enter that into evidence if possible, if you can get your hands on it. But if you can't, as in Lee's case, he was never provided with that information, get it onto the record through their testimony, because that is enough.
Yeah, it's something that goes a little bit beyond the realm of offsets, but I think it's good practical advice to be aware of. Is if a claimant has applied for unemployment compensation in Pennsylvania, they've made an attestation that they're capable of working. So if you're still in the situation where you're litigating the claim petition, it can sometimes, and I don't know how much disputing of UC applications is taking place now, but pre-pandemic, there was a time when it was useful to see what was going on in the UC arena, because sometimes the claimants will actually end up testifying, and they'll testify sometimes in relation to the work injury. So you'll want to If there is a transcript, get those transcripts. There's been occasions where Chartwell attorneys have gone to UC hearings to observe, to see what was provided in the testimony. So I think just as a general issue for employers and obviously insurance carriers, if you see that there's unemployment at issue, I would take a close look at all aspects of that, not just the offset, but what took place in that UC application that might help you in the comp setting.
Definitely.
Severance and pension, those are things that sound complicated. How do you uncomplicate them? What's the approach?
Well, something important to remember is that the offset can only be applied to those funds that were funded by the employer, and that in those four circumstances only applies to severance and pension. It does not apply to unemployment and Social Security retirement. So in a pension situation, that can get a little complicated because they're usually partly employer funded, partly employee funded. And if it's in litigation, you want to remember that you may need to present testimony from an expert in the form of an actuary to talk about the percentages, because it is the employer's burden to show the entitlement and the amount of the offset. So that's definitely more complicated than the unemployment compensation, but it's something to remember, especially in a pension context.
Yeah, and we have attorneys at Chartwell who have done a lot of those, and frankly, when it comes before me, I sometimes bring in that attorney because it is when you've I guess you've presented the testimony of 10 actuaries, it's simple stuff. But if it's something you haven't addressed much in your career, it can be a little overwhelming. So it's good to talk to people who know what they're doing. Kaitlin, I want to do a quick idiot's guide to comp, and I'll be the idiot because I admittedly always have to look this up. Social Security retirement. When am I, as an employer or a carrier, entitled to an offset for a claimant who's getting Social Security retirement?
So you are entitled to an offset only if the work injury happens after the employee starts receiving Social Security retirement. If the person had been receiving it before the work injury, you cannot take the offset.
Okay, so that's something that we can track by sending out the LIBC forms, right?
Yeah, and just to add to that, generally, the offset is actually 50% of the employee's receipt of Social Security retirement. So, for example, if a person is receiving $300 a week in workers' compensation benefits and $100 a week in Social Security retirement, the offset would be $50. So they would receive $250. For their compensation benefits. But to answer your LIBC question, yes. LIBC 756A, it's Employees Report of Benefits, and the employers or carriers should be sending those to employees every 6 months so that they can fill it out, send it back. That's good because in a situation where there is an overpayment and a recoupment issue, if we're sending out those forms every 6 months, the court doesn't have to go through a undue hardship analysis. Basically, is the claimant going to suffer if we take that repayment? Because if we've been sending those forms out every 6 months, the employee has to send those back. That's on them.
Yeah, I think that's good advice. I think also on the Social Security retirement, where it comes up, obviously it's an issue for the immediate offset. If somebody starts receiving Social Security retirement, next week, you need to consider your offset. And Kaitlin outlined how you do that math, which again, I have to look up every time. But I think another instance in which you want to consider that is when you're talking about settlement. So if you have somebody who's 65 or 64, obviously you're concerned about the Medicare set aside, but you also need to recognize if there's a Social Security retirement issue there. So
absolutely.
I think that covers those aspects of Pennsylvania workers' comp offsets. Lee, did you have anything to add on the non-CARES Act stuff?
Just two things. I had a running checklist here, but Kaitlin covered it all. You can't force a claimant to receive a benefit they're eligible for, but elect not to receive. So even though we might want the claimant to start receiving Social Security retirement at a younger age so we could get our 50% offset, you can't force them to do it. You can't even force them to apply for unemployment compensation. So even though they're eligible for a benefit, it doesn't mean that the offset happens. They actually have to receive the benefit. In general, the lawyers I know always ask claimants questions regarding all four of these types of offsetable benefits. But I think that our adjusters, when they're making their 3-point contact with the counsel, with claimant, and with their insured, should also ask the same questions, especially of claimant. You know, are you receiving UC? Are you going to apply for it? Same for severance, pension, and Social Security. You know, it gives them better clarity as to what their adjuster's exposure might be. But I have nothing else to add. Kaitlin, you're a rock star.
Yeah, and I think from Lee's advice, that the important word that jumps out to me is the "have you applied for" question, because claimants are good at answering questions because they've been well prepped by their attorneys, and any attorney preparing someone for cross-examination will tell them that you only answer the question that was asked. So if you applied for UC 2 weeks ago and you're not going to get your first check until next week, and enterprising lawyer Jason Hanford says, "Hey, are you receiving UC?" The correct answer to the question is, "No, I'm not, but I will as of tomorrow." So, and they're not going to provide that testimony about as of tomorrow because I didn't ask about it. So for the attorneys out there and for the adjusters, when they're getting involved in the claim, make sure you ask if an application has been made. It applies across the board. If they've applied for Social Security disability, that could be a 18-month process. So I think it's good to ask, did they apply? Not only are they receiving. Anybody have anything else?
One other thing I just wanted to add is one other LIBC form, and it's LIBC 761. Basically, employers can take the offset unilaterally. They can just go ahead and do it, but you do have to give the claimant 20 days notice, and that's that LIBC 761. So just keep that in mind when taking the offsets.
Yeah, especially because when you've got to that situation where you have a valid offset, you don't want to get tripped up later on by missing out on a form, because I think most judges are going to hold you to that. And you might even get penalized for wrongfully taking an offset. So make sure you dot all the I's and cross all the T's. Lee, anything from you?
I'm done, Jason. Thank you for your time.
Okay, well, we hope everybody stayed awake throughout the whole video. It's, as I said in the beginning, a bit of a nuanced subject, but I think it is an important subject. So if you have any questions, please feel free to reach out to Kaitlin, reach out to Lee. You can reach out to me as well. I'll probably just send you to them. But it's an important topic, and maybe we'll get an update from Lee on his CARES Act case at some point, because it sounds like that's going to be potentially some new law in the Commonwealth.
Thanks, Jason.
All right. Thanks, guys.
Thank you, everybody.